Evet hocam geçtik.
Distinguished guests, welcome to a webinar organized by Dispute Resolution Center of the Ibn Haldun University. Um, Today, we are going to speak about UK and French arbitration law and practice 2025 year review. Our first speaker is Dr. Doğan Gültutan. He's a partner and solicitor advocate at Graymore and a senior lecturer at the City Law School. He specializes in international commercial arbitration, investment arbitration, and complex commercial litigation. He is dual qualified in England and Wales and Turkey. He frequently represents multinational corporations and sovereign states in high-stakes multi-jurisdictional disputes across the energy, finance, construction, and technology sectors before major arbitration institutions like the ICC and the LCIA. Doğan, the floor is yours.
Thank you, Hojam. My thanks to Hojam and the Ibn Haldun University for the kind invitation. So this session, we will be covering the developments in UK arbitration, English arbitration law for the past year, principally the cases and the reforms that have taken place in 2025, and also a case from 2026. So let's have a look at the contents. This will be a presentation for about 15 to 20 minutes duration, and then there will be opportunities for questions. So it will be a whistle-stop tour of the developments that we've seen in English arbitration law in the past 12 months. So first, we'll take a look at we will do an introduction into English arbitration, what the applicable law is, and the framework, legislative and the judicial framework. Then do a slight deep dive into the Arbitration Act 2025, the new legislation that we have here in England and the UK, and discuss whether the Act is a reform or an evolution of the arbitration law and the landscape in England. And then finally, and most importantly, we have a section focusing on the landmark arbitration cases delivered by the English courts in the past 12 months, focusing principally on four broad categories of issues. The first being state immunity. How does a state's immunity impact the ability to enforce arbitral awards against it in the jurisdiction? Dispute resolution clauses, do they apply? Are they valid? There are some cases which have discussed this issue. The confidentiality of arbitration, and there has been a case which has discussed this aspect of arbitration with a unique set of facts. And finally, time limits, what time limits apply, especially in connection with the commencement of challenges, or the initiation of challenges or appeals against arbitral awards, and whether there is a strict need to comply with those limits. So that's the general outline of the talk. So let's do an introduction into English arbitration. The arbitration in England and Wales is governed by the Arbitration Act 1996 as amended, principally by the 2025 Act, and we will come on to the principal amendments through that Act in a minute. And essentially, of course, it's impossible to summarize the Act in a speedily fashion, but the principal point to make is that the Act adopts a non-interventionist approach. The courts are not permitted to interfere with arbitral proceedings unless they are expressly authorized by the legislation. Now, of course, England is, I would say, arguably the epicenter of international commercial arbitration. So a change in arbitration law in England, whether in the statute book or case law, tends to have a significant impact on the global scale, tending to have seismic repercussions. This is attributable both to historical factors and to the significant role played by the English courts. England is one of the most popular seats of arbitration. In fact, it's the most preferred seat in various jurisdictions. The LCIA, the London Court of International Arbitration, the principal arbitral institution on the land, has a lot to do about that. It has been in existence since the late 1800s and served well the arbitration community. Now, with a revamped arbitration law that received royal assent in 2025, that's the Arbitration Act 2025, which amends the 1996 Act. It appears that England will continue to be that beacon of arbitration. So the Arbitration Act, as I said, adopts a non-interventionist approach. And once an arbitral award is rendered, there are principally two mechanisms of challenging or having recourse against arbitral awards. The first is that the challenge could be brought under Section 67 or Section 68 of the Act. The former refers to substantive jurisdiction of the tribunal. The latter refers to concerns any serious irregularity in the proceedings. And rather unusually, taking a different turn when compared with the model law jurisdictions, there is a right of appeal against arbitral awards under Section 69, but of course the parties can opt out of that mechanism. Another component of the arbitration landscape in England and Wales and why it's so popular is that it's the English court, the commercial court in particular, which hears arbitration matters, is very respected and its decisions has been widely acknowledged as being correct. And the courts adopt a pro-arbitration approach, again, comply and adhere to the spirit of the Act in the sense that it does not intervene unless it really has to. And the fact that under the civil procedure rules, the procedural rules that apply to court litigations, there is a specific part 62, which concerns arbitration claims, also shows that arbitration claims are treated differently in certain respects in an effort to ensure that arbitration is final and binding. So that is hugely respected by the courts. Now that's a general introduction into arbitration in England and Wales. As I said, we have a new act. The Arbitration Act 2025 is not a self-standing enactment. It simply amends the 1996 Act and therefore references to, so when referring to the relevant legislation governing arbitration or concerning arbitration, it is still proper to refer to the 1996 Act as governing arbitration matters in England and Wales. The 1996 Act enjoyed immense popularity and remained largely untouched for about a quarter of a century. However, judicial testing of its provisions surfaced some shortcomings. So, for instance, in the UK Supreme Court's approach in ENCA to determining the law applicable to the arbitration agreement, which was at odds with the approach taken in many other jurisdictions, other famous jurisdictions such as Paris, and Jen will tell us about that, I guess, in a minute. But the divergence was a factor in the Law Commission, the Ministry of Justice, instructing the Law Commission, the UK Law Commission, to conduct a review of the Act, and that ultimately culminated in the enactment of the Arbitration Act 2025. That piece of legislation received its royal assent on the 24th of February 2025 and came into force on the 1st of August 2025. So since the 1st of August, its provisions have kicked in. Now, what are the main amendments introduced by the 2025 Act? They are as follows, and I will say there are 6 principal amendments. The first is that the Act stipulates that the law applicable to the arbitration agreement is the law of the seat of arbitration, unless the parties have expressly agreed that the law that applies to the arbitration agreement, unless the parties have agreed, unless the specifically parties have agreed otherwise. Now, this reverses the effect of the UK Supreme Court's decision in ENCA, in which the Supreme Court said that essentially, absent any express agreement, the law applying to the underlying agreement will generally be deemed to apply to the arbitration agreement. So that has been reversed. The amendment aligns English arbitration law with the other centres of arbitration, where the law of the sea generally applies to the arbitration agreement. That's the first and, in my opinion, most fundamental amendment introduced by the 2025 Act. Secondly, arbitrators are now under an express statutory duty to, and I quote here, disclose to the parties to the arbitral proceedings any relevant circumstances of which the arbitrator is or becomes aware. And relevant circumstances being circumstances that might reasonably give rise to justifiable doubts as to the individual's impartiality in relation to the proceedings or potential proceedings concerned. That's in Section 2 of the 2025 Act. Now, this is not a new phenomenon, but this simply codifies the test as it had been formulated by the UK Supreme Court in a case called Halliburton and Chubb in 2020. But the fact that this has been now expressly codified into legislation is significant, in my opinion. Thirdly, the 2025 Act provides arbitrators with some level of protection through immunities against liability. And essentially, the takeaway is that arbitrators are immune unless it can be shown that they acted in bad faith or where they resign and their resignation is unreasonable. Again, I think a proper amendment. Fourthly, the 2025 Act provides confirmation that arbitrators may award costs in their awards, despite a finding of absence of substantive jurisdiction. So even where the arbitrator finds that it had no jurisdiction because of the invalidity of the arbitration agreement, let's say, it nevertheless has jurisdiction to award costs. And again, there was case law confirming that, but this puts it on statutory footing. Fifthly, the 2025 Act confirms and grants arbitrators express powers to make an award on a summary basis in relation to a claim if the tribunal considers that a party has no real prospect of success on the claim or relating to the issue. And of course, this is unless the parties agree. So if the parties haven't agreed otherwise, the tribunal has summary disposal powers, where the tribunal considers that the claim or the defence has no real prospect of success, then it can summarily dismiss the whole claim or part of it. Sixthly, the 2025 Act expressly recognises that the court's powers available for use in support of arbitrary proceedings contained in Section 44 of the 1996 Act may be exercised against third parties. So the court's power in terms of, for instance, in assisting with the gathering of evidence, that power can be addressed towards third parties and not just to the parties of the arbitration agreement. So those were the fundamental amendments and changes brought about by the Arbitration Act 2025, and which has now amended the 1996 Act. Now let's look at the landmark arbitration cases that have been before the English courts over the past 12 months. The first case that I will be starting with is the case of Border Timbers / ISL v Zimbabwe / Spain. And keen eyes will observe that this was a case that I mentioned during last year's summary of the key arbitration cases in the UK. But of course, that was a Court of Appeals decision. Now we have the UK Supreme Court's decision. So this case demonstrates that the reverence and respect that the English courts have for the arbitral decision making. So in Border Timbers, the UK Supreme Court held that accession to the ICSID Convention, i.e. by becoming a member by acceding to the treaty, such constitutes submission to jurisdiction. The court heavily relied on Article 54(1) of the ICSID Convention, which requires contracting states to recognise and enforce ICSID awards as if they were final judgments of domestic courts. And the court said that this obligation, this reciprocal nature of the obligation, necessarily involves an express acceptance by each contracting state that if an ICSID award is rendered against it, then every other contracting state must exercise jurisdiction. Now, this case was a case where both Border Timbers and Spain were attempting to enforce ICSID awards obtained by the two claimants, the companies, against Zimbabwe and Spain, respectively. These were separate proceedings, but at the Court of Appeal level, because they involved similar issues of law, they were merged and heard together. They were conjoined appeals. And similarly, at the UK at the Supreme Court level, when it was further appealed, again, both cases were heard together. Now, in both cases, the states raised immunity as a reason why the actions could not be brought against them. Either they were immune from suit, immune from the adjudicative jurisdiction of the English courts, and they relied on Section 1.1 of the UK State Immunity Act 1978, which says a state is immune from the jurisdiction of the courts of the UK, except as provided in the following provisions of this part of the Act. So unless you can show that you fall into one of the sections, one of the gateways that permits you to bring a claim against the state, you cannot bring a claim against the state before the English courts. Section 2.1 says, and this is the submission to jurisdiction gateway or exception, a state is not immune as respects proceedings in respect of which it has submitted to the jurisdiction of the courts of the United Kingdom. And the question before the court was whether by becoming a member, by acceding to the Exit Convention, there was a submission to jurisdiction and therefore a waiver of jurisdiction, in which case Section 2 will allow the investor to bring enforcement proceedings against the state. And both the Court of Appeal and the UK Supreme Court held that there was a submission to jurisdiction. The Section 9 argument, Section 9 says alternatively, where a state has agreed in writing to submit a dispute which has arisen or may arise to arbitration, the state is not immune as respects proceedings in the courts of the United Kingdom which relate to the arbitration. So that was an alternative ground on which the investors relied and said, this is an exit arbitration award we are trying to enforce. And therefore, because the states have agreed to arbitrate the dispute, these proceedings relating to the arbitration are therefore, they fall within Section 9, and as such, the states cannot plead immunity. This point was not considered by the Court of Appeal or the Supreme Court because the Section 2 argument was dispositive in the sense that the court need not have addressed the point. So it remains to be seen what the Supreme Court thinks about Section 9. But essentially, the takeaway from this Border Timbers case is that a state who has acceded to the Exit Convention will be deemed to have submitted to the jurisdiction of the United Kingdom courts by virtue of Section 2 and therefore cannot plead immunity from suit. Now, that's different from immunity from execution, which is whether you can enforce the assets of the jurisdiction. Another landmark case is the case of General Dynamics and Libya. It's a Court of Appeal decision from 2025. In this case, the Court of Appeal held that an arbitration agreement which stipulates that the award of the arbitrator shall be final, binding, and wholly enforceable is sufficient to waive state immunity. The reference to the use of the words wholly enforceable was critical here. The case had the following facts. General Dynamics agreed to supply a tactical communications and information system to Libya in return for £84 million. The contract was governed by Swiss law, with disputes to be resolved via ICC arbitration. The arbitration clause provided that the award of the arbitrators shall be final, binding, and wholly enforceable. The tribunal ruled in favour of General Dynamics and ordered Libya to pay around £16 million, so substantially less than what had been claimed. Libya did not voluntarily comply with the award, so General Dynamics issued its claim in the English High Court. Libya resisted that enforcement on the basis of its immunity from enforcement. So this is the immunity from execution or enforcement, and not from suit, which was the subject matter of the Border Timbers case. Under Section 13.3 of the State Immunity Act 1978, the UK Act, immunity from execution over a state's assets is waivable, provided that the state provides written consent, and such consent may be expressed so as to apply to a limited extent or generally, but a provision merely submitting to the jurisdiction of the courts is not to be regarded as a consent for the purpose of the subsection. So essentially, you need clear words to show that the state has waived its immunity from enforcement, and simply saying disputes are to be resolved in the English courts, for instance, will not be sufficient. Libya argued that the contents of the arbitration clause could not be construed as such written consent. The High Court disagreed and held that the relevant words did amount to consent. So a final charging order was accordingly made in favour of General Dynamics against a property in London, which was owned by the state of Libya. Libya then appealed that decision, but again, the appeal was dismissed, and the Court of Appeal, as I said, held that there was the language was sufficient to constitute a waiver of state immunity from enforcement. The judgment, in my opinion, illustrates that reference to enforcement or enforceability, particularly contractual words indicating that words are wholly enforceable, are likely to suffice to defeat the last bastion of state immunity as it is, because once essentially on an immunity basis, a state can argue 2 points. The first is that it is immune from suit, immune from the adjudicative jurisdiction of the courts. Failing that, it is immune from execution. And this is that is why it is referred to as the last bastion of state immunity by some. So parties entering into contracts with states or state entities will therefore be well advised to insert such words into their contracts to ensure that their attempt to thrash the last bastion yields fruits. Let's take a look at another. This is, I believe, the final case on state immunity, the case of CC Devas and India. And this is a commercial court decision from 2025. The commercial court in this case, and that was Mr. Justice Blair, and he is Mr. Tony Blair, the ex-Prime Minister's brother, older brother. He held that the ratification of the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, i.e. the New York Convention, does not constitute a submission to jurisdiction under Section 2 of the 1978 Act, and therefore drawing a difference between ICSID and New York Convention. For ICSID, as you remember in the Border Timbers case, the UK Supreme Court held that accession to the ICSID Convention was a sufficient waiver and a submission to jurisdiction for Section 2 purposes. But Mr. Justice Blair said that membership to the New York Convention does not have the same outcome. In that case, you had a Mauritian company's shareholders and investors who commenced treaty proceedings, BIT claims, against India for India's failure to accord fair and equitable treatment. That the investors succeeded and they were issued an award in their favour of around 195 million euros. India then attempted to resist enforcement on the basis that it was immune from the jurisdiction of the English courts, relying on Section 1 of the 1978 Act. India argued that Section 9 arbitration waiver did not apply because there was no valid submission to arbitration. So India said, we do not have a valid arbitration agreement. The New York Convention does not constitute a submission to jurisdiction for the purpose of Section 2, and therefore Section 1, the general immunity protection provided to states, applies. The question before the court was whether there had been a submission to jurisdiction within the meaning of Section 2. The court was invited to rule also on the Section 9 argument. As I said, the court held that there was no submission to jurisdiction, merely by virtue of the New York Convention's ratification. And the critical point here that was made was Article 3 of the New York Convention. The fact that the convention directed each contracting state to recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon, meant that the immunity grounds, which were procedural matters, were not displaced, and therefore any enforcement under the New York Convention will still have to observe the internal procedural rules of the territory, which include state immunity issues. Now, I personally do not find the reasoning to be particularly persuasive. I think that Article 3 of the New York Convention expresses directs contracting states to recognize and enforce our New York Convention awards. That direction is admittedly subject to the rules of procedure of the courts where the award is being enforced, but that is, I submit, a too tenuous ground on which to differentiate treatment of ICSID and New York Convention awards. Adopting a teleological approach to interpretation, an approach that was sanctioned by the UK Supreme Court in Border Timbers, dictates that states that have ratified the New York Convention also should be considered as having submitted to the UK court's jurisdiction. So I think that a similar analysis should follow. But of course, that's not where English law stands. If you have a New York Convention award, you are still subject to the state immunity rules, and there will be no deemed submission to jurisdiction. So let's move on from state immunity and consider dispute resolution clauses. The first case to look at is the case of Technicas and Petroleum Chemicals. Again, a commercial court decision, an English commercial court decision from 2025. This case concerned a Section 67 challenge under the 1996 Act to set aside a partial award in which an ICC tribunal had upheld its jurisdiction. So this was a challenge against the jurisdiction of the tribunal. The dispute concerned competing dispute resolution clauses in a subcontract between the parties, associated with several documents subject to a hierarchical structure. The subcontract between the parties included a hierarchy of documents. There was a purchase order which took precedence and then other contractual documents. The purchase order included an arbitration clause, a clause 11.1, which provided that disputes be submitted to ad hoc arbitration in London before free arbitrators under English law. However, there were two other documents lower in the hierarchy, which included competing arbitration clauses, clause 32 of the general terms and conditions, provided for IC arbitration in Riyadh, subject to Saudi Arabian law, whereas item 18 in a deviation list, another separate document, referred to arbitration under ICC laws. So the question was whether which of these clauses were these clauses harmonious, were they consistent? If so, if inconsistent, which one should prevail? Failing to establish jurisdiction before the Saudi Commercial Court and the LCIA, defendant filed with the ICC, arguing that clause 11 and 32 together establish jurisdiction for a London-seated IC arbitration under English law. In its partial award on preliminary issues, the IC tribunal agreed and held that it had jurisdiction. The claimant Technicas then challenged that partial award under section 67. The commercial court, this time Mr. Justice Bryan, upheld the challenge and determined that where an arbitration agreement provides for ad hoc or institutional arbitration is a matter of challenge under substantive jurisdiction. According to the judge, the distinctions between the two choices were also fundamental. For instance, in an IC arbitration, the ICC court appoints presiding arbitrator and scrutinizes awards. Accordingly, the judge explained that ad hoc arbitration and an institutional arbitration under the ICC rules are fundamentally different beasts. As a result, the classification between them was substantive, and therefore the incorrect finding finding by the arbitrator that he had jurisdiction on the basis of ICC rules was an important one. Of course, there's more analysis to go through, but I know I'm short on time, so I'm going to whiz through. A detailed note on these cases will be published later on by the Uçam institution and in Holding institution, so I'm not going to dive much deeper into the court analysis there. A second case we have is the case of FH Holding and Unicredit. Again, a commercial court decision from 2025, where there were overlapping dispute resolution clauses in separate contracts. This time, Mr. Justice Henshaw, sitting at the commercial court, refused an anti-suit injunction sought by a Cypriot borrower against its Russian and Italian lenders to restrain mortgage enforcement proceedings in Moscow. And essentially, there you had the borrower had entered into a facility agreement, and the facility agreement contained an arbitration clause foreseeing arbitration in Vienna before the Vienna International Arbitration Center. But there was a separate mortgage agreement entered into between the parties, and that agreement foresaw disputes to be resolved via the Moscow Commercial Court. And the defendant argued that its actions before the Moscow Commercial Court were expressly permitted by the terms of that mortgage agreement. The fundamental question there was the coverage of the dispute resolution clauses and whether one outstayed the other. The court held that although the facility agreement stipulated for VIAC arbitration in Vienna, the foreclosure proceedings were validly issued pursuant to the terms of the mortgage agreement, and as such, there was no breach of the arbitration agreement. The mortgage agreement expressly permitted such foreclosure proceedings. Accordingly, on its interpretation, it seemed to the court that the parties intended claims to be brought before VIAC tribunal and/or Russian courts, depending on the factual matrix. The case demonstrates, I think, the importance of aligning dispute resolution clauses in separate but related contracts to avoid unnecessary litigation, where it is clear from the suite of documents that the parties intended for different dispute resolution mechanisms to apply to different contracts. Such intention will be given effect, and therefore it is why I say it's key that you avoid overlapping, inconsistent dispute resolution clauses in related but separate contracts. Another case about the scope and reach and applicability of dispute resolution clauses is Hypnosis and Barry. It is a Court of Appeal decision from 2025. This case is a case where the Court of Appeal rejected the concept of floating jurisdiction in the context of an asymmetric dispute resolution clause, and the clause that the words of the clause are on the slides. The question was whether the English court lacked jurisdiction once US proceedings were commenced after commencement of the English proceedings. So could there be a floating jurisdiction in the sense that could the English court's jurisdiction be taken away and floated back to the US once the relevant party has exercised its asymmetric right of initiating proceedings in a different venue. And the Court of Appeal allowed the appeal against the commercial court's judgment, and that was a judgment from Mr. Justice Marcus Smith, and held that the jurisdiction of a court is determined at the commencement of proceedings, and therefore rejected the concept of this floating jurisdiction. So, if at the time of commencement of the proceedings, the relevant court, the English court, has jurisdiction, that will crystallize its jurisdiction. The fact that the other party then goes away and commences proceedings in another venue, which is permitted by the contract, will not rob the English court of its jurisdiction. So that's, I think, it's a commonsensical decision, but it's good to clarify such matters. So it's a decision to be welcomed. Confidentiality, as we all know, arbitration is generally confidential. Of course, not in all jurisdictions is it expressly or implied confidential. But under English law, there is an implied duty of confidentiality. This question concerned the issue of confidentiality of proceedings in circumstances where you had a single law firm, an international law firm, acting through its separate offices, acting for two unrelated claimants in separate arbitrations, but involving companies under common ownership. Could that be a breach of the arbitration agreements, of the confidentiality, in the sense that information about one arbitral proceeding could be known or released or made known to the other office, and therefore a breach of confidentiality obligations? An injunction was sought to prevent the firm from acting, but that injunction was refused. It's a very long case, and it's a case with complex factual structure. I don't think I have sufficient time to go through it, but if you're interested in confidentiality in English arbitration, it's a worth read. It sets out the general principles that apply in English law in respect of confidential arbitrations, i.e. the implied duty of confidentiality and the various exceptions to it. One point to note is that the court in this case said that there would be a sliding scale of analysis, in the sense that confidentiality may attach with varying intensity to different categories of documents and information. So it's not a black and white approach, even where there may be a breach or a possible breach of the duty of confidentiality. The relevant the nature of the document information will be assessed to see if, despite that risk, an injunction should be granted. We've got two more cases, and quickly to deal with those so that I'm not stealing too much time from Jem. These two cases I have to discuss are about time limits. In this case, in JSC Kazan Oil Plant and Aves, again in a commercial court decision from 2025. In this case, the commercial court confirmed the strictness of time limit for an action to challenge an arbitral award under the 1996 Act. The appeal was lodged on the 28th day after receipt of the appeal award. This was a phosphor arbitration award, but that was more than 28 days after the date of the said award. And the court had to consider whether the 28-day period ran from the date of an award or the date on which the award had been notified to the parties. The court held that the 28-day period started to run from the date of the appeal award. Subsection 3 of the 1996 Act was clear that an appeal or a challenge had to be brought within 28 days of the date of the award, where no further appeal or review lay against the awards. But of course, note that the 2025 Act has amended the 1996 Act on this particular point, so the rule is slightly different. But in this particular case, the delay of 15 days meant that the court blocked the ability to challenge the arbitral award. And although 15 days delay may not seem too substantial, the period that you have under the 1996 Act to challenge an arbitral award or appeal against it is 28 days. And the court made a note that that was over 50% of the entire time allowed by Section 70, subsection 3 of the Act. So even a couple of days delay may block a challenge or appeal being brought against the award. Finally, I know patience is running thin, so the final case I have is African Distribution and Alstar. Again, another commercial court decision from 2025. In this case, the commercial court dismissed an application to extend time for challenging an arbitral award. but it did leave it open whether a non-participant party could challenge the awards even after the 28-day period. And that's because Section 72(1) allows that challenge to be brought, and there is no time limitation attached to that ability, to that right. In terms of the dismissal of the application to extend time for challenging the arbitral awards, the court said that essentially the application was not promptly made and the delay was over 5 months, 159 days to be precise, and the court found that to be a substantial delay. So if you are going to be making a request to the English courts for an extension of time to challenge, you should make that application promptly and without delay. And I do apologize if I've been over my time, but that's all I have. And I'm open to questions now or at the end.
Thank you very much for your comprehensive analysis, Doğan. The questions will come at the end. Our next speaker is Cem Kalelioğlu. He is a London-based partner in the litigation, regulatory, and tax team at Pinsons Masons. He specializes in complex international commercial arbitration and investor-state dispute settlement. He is a triple qualified lawyer admitted to practice in England, Wales, Ireland, and Turkey. He regularly advises governments and multinational corporations across the energy, construction, aerospace, and defense sectors. Cem will speak about year review of French arbitration law and practice. The floor is yours, Cem.
Thanks very much, Aliojo. I'm going to try to share my screen quickly, if I can. Oh, I think we got it. That's great. Well, first of all, thank you so much, Aliojo, and for Doğan, who makes a great points that I will quickly address as well. I want to fix one thing, and the reason that I'm speaking about French law, French arbitration law, is going to make more sense. It occurred to me that I'm actually qualified in 4 jurisdictions, not 3. I am also, for some reason, qualified in Kazakhstan with the financial court, and most of my legal studies I did in France, and so that also goes to show the breadth of the practice that we are having in London. As Aliojo said, I'm doing a lot of investor states disputes because of the public international background, but also commercial cases that we do are not really limited to English law only. We do a number of cases in various jurisdictions that I'm not even qualified. Obviously, we do them with co-counsel in those cases. So I agree with Doğan that London is definitely the headquarter, if you will, of international arbitration, or more generally international disputes. So before starting, I will make a quick observation on French arbitration law. So French arbitration law is boring. It's not it doesn't involve cases like ENCA that Doğan mentioned. They are just doing the right things, the things that we want to see in a pro arbitration jurisdiction. On that note, this is a quick roadmap, just explaining why. I will start with why French arbitration law matters for us, and then I will look at the 2025 reform project that the French government came up with, and then I will wrap it up very quickly on landmark decisions of 2025. So why French arbitration law matters? So I think the answer is very, very short. France really did not merely adopt international arbitration. It helped invent a modern version of it. What I mean with this, whenever you see an arbitration practitioner talking about the jurisdiction or the seat, first thing they would see like how the courts in that jurisdiction would react to arbitral awards or arbitration in general. And we want to see courts understanding the international concepts of arbitration. And France actually came up with this idea in 1980s, like way before than many other jurisdictions. And they said, look, we need to create a mechanism that where we do not really touch what the arbitral tribunals do and keep it really liberal, so that the seats France can be given, can be chosen as preferred seats, and they did that in 1980s with the first decree, and that comes even before unilateral model law, on which many states base their arbitration laws. So those decrees now are codified in Code de procédure civile, which is something like procedural code, if you will, the one that actually we have in Turkey as well. So why France is trying to do this? I think the message is quite clear. So France, as you look at the history, France has always been a pioneer when it comes to bureaucracy, like resolution of the disputes. But obviously, after the Second World War, France's role kind of reduced. If you look at, I'm going to take give an example from schools, even in Turkey. If you look at like really established schools like Galatasaray, like a bunch of other French schools, they always, provided their pupils in education in French. But that trend later shifted. So one of the ideas that France had is that they had to keep their role as a center of resolution of the disputes. As you can see on this slide, basically this French government is talking about why they are trying to reform the arbitration law in 2025, because there's nothing wrong with it, right? Like French arbitration law is just perfect. And in this, the government says that c'est une stratégie d'influence, which means that it is a strategical influence strategy, which is, this is what they're trying to do. They want to show the world that France is a pioneer and people like the other states need to follow France. And there's some truth in that. We talked about the French government's, policy to keep arbitration liberal and to keep keep arbitration attractive so that the international disputes can come to France. But you can only do that with really good judicial system. And when you look at the French case law historically, you look at, for instance, like now in all the universities, you would see professors teaching separability, which is very important concept in international arbitration. That very concept actually comes from the Dalico case in 1993, where the French courts decided that an arbitration agreement itself is separable from the matrix of the contracts, or like sometimes English courts call it severable, or US courts this way. So that was, that decision was actually influenced other jurisdictions to come to similar results. And then you see Hill-Martin decision just 1 year after. It is where the courts decided that an arbitral award that was set aside in the seat of jurisdiction can nevertheless be recognized in France. So whether or not you like the approach, there is some logic to it, because when you apply for recognition and enforcement, you basically try to see whether the award itself can be considered as a final judgment in that jurisdiction. But also, some say that this is wrong when it comes to the New York Convention. So France is pioneer of these things. They do whatever they can when it comes to international arbitration. For instance, in Turkey and many other jurisdictions, under Article 5 of the New York Convention, we look at public policy, and we criticize some jurisdictions, and Turkey has been one of those for some years. Now we're doing things much better, but back in the days, Turkey was also criticized that the courts approaching public policy issues quite narrowly. The French courts came up with the idea that we not really care about public policy, we care about international public policy. We don't know what international public policy is still to this day, but this is a way sort of for them to say that even public policy concerns should not be construed narrowly to set aside awards. So we looked at the government policy, courts, what else we need to make a country or city as a hub for arbitration. That is an institution. That is an arbitral institution. So Paris has been home to ICC for more than 100 years. They host ICC, and ICC, as you know, has been conducting over more than 10,000 of arbitrations. It is probably the most used institution. Although we see a lot of increase, especially in Asia and the UK, thanks to LCIA and SIAC, ICC is always sort of taking the lead of institutional arbitrations. So I think you've heard Doğan discussing ENKA, and I think he might have referred to Kebapçı, because Kebapçı is also quite similar case to ENKA, where the English court decided that the law governing international arbitration agreements is the law of the contracts. So they did that in a number of cases, and there has always been a tension between Paris and London. And Kebapçı is a good example for that, because both decisions, Kebapçı decision, the same case was reviewed by both French courts and English courts, and they both came to different results. And we liked the French approach, because the French approach was sort of liberal approach that says that the law governing international arbitration agreements is the law of the seats in the absence of an express language in the arbitration agreement. So this is not the only case. Dalla case was pretty much the same, conflicting results. And when you look at both courts, the French courts, you can see they're liberal, substance-driven, but when you look at English courts, they're very black letter, text-based, contract law, whatever is written in the contract. That actually explains the tradition between two systems, because, as you know, French law is civil law, which as when we have a contract in a civil law, it can say things, and you need to look at what it says. But at the end of the day, intention of the parties always prevail. English courts are a bit more than that. They're text-based. They're more rigid, as we call black letter approach. And that is sort of has been the approach to arbitration as well. French courts saying that they decided to arbitrate, so we need to pave the way to the parties' consent. English courts looking at the contracts more broadly, trying to see whether the consent to arbitrate exists, etc. So this long divergent approach between the two jurisdictions kind of narrowed in 2025 or when the UK government, as Doğan mentioned, decided to reform the 1996 Arbitration Act. And it was timely because as you might know, UK, well, England, Wales, is a common law driven jurisdiction, which means that if the statute, which is Arbitration Act, doesn't say anything, it cannot overall, it cannot prevail on the common law approach, which was created by Kebapçı Enka, and it was going to go ahead along the way. And you can see that the English courts saying that, discussing the Arbitration Act in the Ruschem versus Unicredit case, where they even say that, yeah, we're following common law approach, but we acknowledge that the English Arbitration Act is going to say different things. So I think this is really important to note. UK Arbitration Act came into power in August 25. But the consultation for the act started much more than that. If you look at the French reform project, it started in March 2025. So you can see that there's a little competition between them. When UK government decides to reform UK Arbitration Act, French government thinks that this is a problem because it will actually steal whatever left them to have in international arbitration world. And I think they should be worried because you cannot really deny the importance of English law, in English language, and English arbitration. And if you have really liberal system, there is no way France can beat that. Because French law, as much as I like it as a civil law trained lawyer, is not addressing the things that we want in international commerce, if you will. And we cannot deny the fact that 60% or 70% of contracts in this continent are subject to English law. And whatever they needed to do something to come up to speed. So they came up with the 2025 reform projects. Reform project has two routes, if you will. One is a long-term project. Yes.
Your presentation is not moving forward. Would you like to share with us?
Oh, sure.
Thank you.
Is it moving now?
I cannot see it at the moment, but
let me try again.
Maybe Doğan can see it.
No, currently there are no slides on the screen. I think it froze for a while, Jem.
Oh wow, okay. Let me try again. How about now?
We can only see a snapshot of the first slide, but not the presentation itself.
Interesting.
If you like,
now we see it. All right.
Yeah, maybe you can manually move between the slides in this way.
Is it you can see now?
Yeah.
Excellent. Okay, well then that means that you skipped. Oh, I skipped all the slides, but it's fine. So yeah, I mean, so 2025 projects has two routes, if you will. So the first one is a much longer project where the French government wants to enact a code de l'arbitrage, which is like arbitration code by itself. So many provisions relating to domestic and international arbitration right now, they're in, as I said, the procedural code, but they want to do standalone arbitration code, so everything is in one place. And this is going to take quite a bit of time. So while waiting for that, they don't want to lose any time. So they also want to reform certain provisions in the civil procedure code so that things are much clearer. When we look at what exactly the French government wants to change, there are two issues. First is they want to switch to monist regime. So France currently, like many civil law jurisdictions, like Turkey as well, there are different rules for domestic and international arbitration. France wants to shift to more common law approach, because monist regime is what we have here in the UK and Singapore and Hong Kong. So they want to merge domestic and international arbitration rules. I think the reason, I mean, you can speculate, but the reason behind that is sometimes French courts can apply narrow can look at things more narrowly when it comes to domestic arbitration, and they can apply a bit more liberal when it comes to international arbitration. That actually creates some problems, because in practice, some obviously lawyers try to use domestic arbitration principles in international arbitration context. So that might be an idea behind that. And then you look at the other principles. I noticed 19 guiding principles, and we're going to look at a couple of them. But these are really, French courts already do. They do it really well. It's just, they just want to clearly state that in law as well, so that the approach is already in the law. So we look at the first one that I noticed, which is about the arbitration agreement, the formalism of arbitration agreement. So previously, under Article 1443, there was a requirement for domestic arbitration for an agreement to be in writing. That requirement is not going to be available anymore, and that means that the parties can enter into an oral arbitration agreement. So I should note that this is actually the position right now in international France's international arbitration regime. But there's a big but, because it is great to be liberal, but we need to recognize that the New York Convention requires arbitration agreements in writing. So in practice, when it comes to arbitration, I think I haven't seen any case where arbitration agreement was entered into orally. So this, I mean, it's great to get rid of this, but I think in reality, arbitration agreement will have to be in writing for, I mean, at a minimum for evidentiary reasons. So very quickly, the reform also simplifies competence. I think there was previously a provision in the current article that says that the parties cannot contract out the competence regime. They simply scrap out that provision, and they do not say anything else, because I think competence rule is quite well recognized, and it is very clear that the parties cannot really contract out in their agreements. So the other provision that I've seen quite important is about procedural efficiency and proportionality. I think this is already, again, in practice used by many arbitral tribunals. They come up with, they have the discretion, first of all, to manage the arbitration however they like it to proceed. But the law now recognizes that in the French arbitration law, and I think this is a good recognition, because it is important to stress that not every case can be managed the same way. You will have cases that involve less amount of money. You need to be more efficient. You cannot apply the same procedures when the case is clearly very straightforward, and it involves a lot of costs to parties. So it is good to recognize that in the law, so that the arbitrator, when deciding, or the tribunal, when they're deciding, knows that the law is on their side. So this is very important. New Article 1466 is something that we see a lot in practice. and I will come back to that when I discuss some of the decisions that came out in 2025. So in that provision, what the law says basically is if you haven't raised a jurisdictional objection throughout the proceedings during the arbitration, you will waive arguing those in annulment proceedings. So why this is important? So annulment proceedings in practice, when it comes to annulment proceedings, both in France and the UK and elsewhere, the courts will have to look at the merits of your arguments, because it's very important, whether, especially these things come a lot in investor-state disputes, because BIT sometimes have very problematic language, and even if the tribunal found jurisdiction, that doesn't mean that that jurisdiction will allow the case to proceed to arbitration. So that's the reason that many courts to this day looked at very creative arguments that weren't really argued in the proceedings. And I should emphasize again, this comes a lot in investor-state arbitrations, and French courts have dealt with that a lot. So I mean, this is speculation, but I think this is one of the reasons they want to make clear that if you haven't made those arguments, don't do that before the court. And I will come back to that in a second. So the fifth rule, the fifth amendment that I've seen, which was not worthy, is something that we experience a lot in practice, is the whether or not you can enforce an interim measure order. So, as you know, in arbitration, we can seek interim measure orders, but the reality is that there is not much remedies to enforce those orders. So let's say you applied for a state to not to do something. There's not really a mechanism to enforce it, because the reason is that interim measure orders are not final awards, so they cannot really be enforced under Nivea Convention. Although there's some conflicting decisions, some courts historically decided to enforce them, but the reality is that they're very difficult to enforce. So what France does is that juge d'appui, which is a specific judge, can provisionally enforce interim measure order. This is very helpful, but that also begs to question what it actually means. So let's say that you asked a juge d'appui in Paris to enforce something against a company that is based in Hong Kong. So how it's gonna work? The idea is great, but I think the lawyers should think really carefully when they're seeking this, because in my view, it can only make sense when something that is being protected is located in France, so that they can provisionally enforce whatever that is. So I think this we discussed this quickly. The new law makes clear that the awards, the only enforceable awards are final awards, and that provisional orders are not really enforceable. And I think we're going to see that in a second as well. So I'm coming to the landmark decision of 2025. As I said, France is a boring jurisdiction, so they don't really take decisions that raise attention to elsewhere in the world. But you will see what I'm talking about. They take in really good decisions. I will start with two companies of our own, two Turkish companies. They relate to similar disputes, investor-state disputes against Libya, arising out of Libya's the coup and then coming aftermath in Libya. So apologies, my screen went again, but I will try to. Sorry, can you see my screen or no?
I think it's frozen again. So we're on the landmark decision on 2025 and Nurul. We can see that slide.
Oh, great. Okay, let me see. You can see anything now? No.
No, you may want to close it, reopen it. It's frozen with the Libyan flag slide.
Interesting. Okay, I'm going to do that quickly. Apologies for
It happens to all of
that.
us.
Is it better now?
It's, if you want to move to the next slide.
Yeah.
Yep.
Okay.
Slide.
So just going to quickly on Neural. So Neural case is quite interesting because, well, for those of you who are really interested in investor-state arbitration, there's always this question of what happens if there is a new BIT and the actions that you claim came before that BIT. I think that happens quite frequently that you might think, especially but Turkey is entering into new BITs or revoking them and reforming them. So these issues come up in those situations, and that's exactly what happened in the Neural case. I think the Libya BIT was in 2009, and the investment predated that. And one of the arguments that the state obviously did was that they're barred from protection. But the French courts, looking at the facts, they found that because it wasn't it was a composite act, if you will. The act didn't really stop. The conduct didn't really stop before the BIT, the new BIT. Neural can benefit from the new BIT entered into with Libya. So the second Cengiz decision is kind of my favorite of this year because this is something that we really forget in international investment arbitration. The tribunal there it is quite unique because tribunal there had not only ordered compensation to Cengiz, but it also ordered Libya to take steps to repudiate basically what they did initially, which was through releasing the outstanding bank guarantee. I think this was quite unique, and the French courts decide that there's no issue with that. And why I find this really interesting is when you look at the draft ILC articles, Article 25 actually talks about restitution. And if you look at carefully, you can see that the actual remedy when it comes to international law is actually restitution, which is to stop something state to do the wrongful conduct and give it back to whatever it took. We often forget that, and the reason is actually within Article 25 itself, because when it comes to investment arbitration, restitution is often not possible because the rule is that if you can award it through compensation, then you cannot really claim restitution. But we have the full reparation principle from the Chorza factory case, which means that you need to make whole the investor. And if it's through restitution, then it should be given alongside damages. And that's exactly what French courts decided. So another decision is the heirs of Sultan Sulu versus Malaysia. That involved really, really strange facts. The arbitration agreement there included a provision that says that the appointment of the arbitrator should be made by someone that doesn't exist anymore. And the arbitrator there, this was, I believe, like 50 billion US dollar case, by the way. It's huge. Arbitrator there didn't really like the decisions of Spanish courts and moved the seat to France. And then the case came before the French courts. French courts found that this is nonsense. I think this goes to say that French arbitration is really liberal, but it's not fictional. So if you do something shady, the French courts will stop you. That they will not apply the liberalism all around. So very quickly, so Ocean Bank Russia case, this raised some questions about the merits, and basically the courts, the French courts came to the same conclusion they did in various other cases, that the challenge proceedings are not the place to argue merits. So the final case is the Acer Gala-Vibult versus Venezuela. This is the case exactly we saw when we were talking about Article 1466. Basically, claimants there tried to make new jurisdictional arguments that they didn't raise throughout the arbitration in court proceedings. And the court, French court, said that you cannot do that. You cannot make jurisdictional arguments if you haven't raised that before. So when I was talking about 1466, or more broadly, the NIV reform, the French courts have already been deciding these issues, but they just want to codify them. And that's exactly an example what happened in this case. So I think this is it on my side. As I said, French arbitration law is boring, but I hope that my presentation wasn't that much. I think we will have some questions from this point on, but Ali Hocam, we are in your hands.
Thank you very much for in-depth analysis, Cem. For question and answer, I will give the floor to Dr. Ömer Faruk Kafalı. He will pose the questions to our speakers. Ömer, the floor is yours.
Thank you, Professor. First of all, I would like to thank both speakers on behalf of our Dispute Resolution Center. It was definitely not boring. It was really enlightening, both on a UK perspective and on the French perspective. I've gathered a couple of questions. I will ask in a row. First, starting with Dr. Gültetan. The first one is like with the 2025 reform, we see, as you have explained, it codifies the law applicable to the arbitration agreement, and there was a different position established with Enka versus CHAP. So do you believe from right now, and as Cem also addressed, there was a clash between this French and UK approach. Could we say we have lost this uncertainty? We have solved this uncertainty issue?
Thank you, Dr. Kafalı. I must say the English are always different in their approach, especially when it comes to comparing themselves with the French. They've had this historical fault of difference, but it's good to see that the English have moved towards where the French are on this. So I think it's a good, it's a proper amendment. Does the codification reduce uncertainty? I think it does, but does it eliminate it? Probably no, because what it's done is the debate has now moved away from a judicial reconstruction of party intention, what the parties intended. The courts had the default to rule that the parties intended that the law applying to the underlying agreement would also apply to the arbitration agreement. Whereas now you've moved towards a more clearer, a statutory default rule in favor of the seat of arbitration. But does that magically resolve, eliminate all of the difficulties? I think not, because you still would likely have an argument around what the parties expressly agreed. Was that expressed sufficiently clear? Because if you go back to the Section 1 of the 2025 Act, which inserts a Section 6A into the 1996 Act, it says The law applicable to an arbitration agreement is A, the law that the parties expressly agree applies to that arbitration agreement, or B, where no such agreement is made, the law of the seat of the arbitration agreement. So essentially, if the parties expressly agree otherwise, the law of the seat will not apply, and then there is likely to be that debate around, well, what did the parties agree on if there is such an agreement? So I think there's some certainty, but not complete certainty.
All right. So I also believe that the new approach is more in line also with the New York Convention's notion. Because of Article 5. So, and secondly, with the new issue of power to make award on summary basis, I think this is already an established systematic in domestic courts and maybe in English domestic courts in the UK. But is this a novelty we will see in arbitration, and how will it affect arbitration? Like, will it streamline the process, maybe faster results?
I think it may. Now, by way of context, in England, as Jen will correct me if I'm wrong, we have summary judgment procedures. So a summary disposal powers are also at the hands of the courts, and they are used, but are they used very often? Perhaps not. And why is that? So I say that the summary disposal powers have the possibility of streamlining the process, but I don't think its impact should be overstated, because you have to show generally that there is no real prospect of success. I'm trying to find the wording. So Section 7 of the 2025 Act, which inserts a Section 39A into the 1996 Act, refers to there being no real prospect of success. And that's similar to the test we have for summary judgment applications. That's a high threshold, that's for one. And also, I don't personally think that we arbitrators, I'm a young arbitrator, maybe Professor Ishidara can correct me, but arbitrators are not as brave as judges. I think some arbitrators, at least, have this due process paranoia, or trying to give the parties a proper procedure to represent their case, put forward their case and present their evidence. And the summary disposal kind of condenses that into a very tight time frame. So it will require arbitrators to be brave, and I'm not sure that we arbitrators can be as brave as the judges, and therefore this tool may be less utilized as it is utilized, say, to the extent that judges make use of them. And also, as I said, the threshold is high because a party has to show that there is no real prospect of success. And without seeing the evidence for an arbitrator or the judge to find that there is no real prospect of success, and therefore to use those summary disposal powers, I think it will only be exercised in the kind of rarest and the most clearest cases. So it does have the potential of streamlining arbitrations, but I don't think we should overstate its impact.
If I may
as a final note, sorry, Jem, to cut you in. As a final note, the arbitrators arguably have always had this power. Because arbitrators have a general power of case management, there have been examples where arbitrators have exercised the summary disposal powers, and it has been underused. The fact that it is now an express statutory right, would that increase its use? I have my questions. Sorry, Jem.
No. I totally agree with you. And I think in investor states arbitrators, I think we use that more than in international commercial arbitrators. Of course, in ICSIDs, there's a clear provision in convention that allows the tribunal to decide that the claim is manifestly meritless or something along those lines. And I totally agree with you. I think this is a due process issue. And I sense that if the institutional rules had a similar mechanism, I think they would be extremely comfortable taking those decisions. But I totally agree with that. Having this in the law doesn't really move the needle, because at the end, it's a consent issue. And if the parties didn't really agree to that, it is, it's very challenging. Although, I agree that it would be quite helpful, actually.
Yeah, I'm generally not pessimistic. I'm optimistic, but with this, I'm slightly pessimistic. But that said, having express statutory provision, it may, encourage a cultural shift, and it may bolden us arbitrators. So hopefully, it will move us in the right direction.
Exactly, and Sorry,
Yes,
one
please.
thing, one other thing to add. I think there is also some arbitrators, especially in the UK, Don, you know it better than I do. They love to have list of issues, for instance, like when it comes to hearings. So they actually love to like streamline issues. And if the case is meritless, like there's no point. It's just a cost issue. Like, it's not good for anyone. Like it's really bad. Like if you have a client and you've fought so long a case that was never gonna win, and it's bad for everyone. I think there should be change in trend. Like I know that you're pessimistic on that front, but I strongly believe that it's something that we need to come up with to reduce these issues.
All right. So just quick questions. Would you, as a council, prefer the arbitrators to have such power?
Depends
Yeah.
on which side I am.
All right. Okay.
Totally
Yeah.
agree.
Yeah.
I mean, from a neutral standpoint, I think yes, arbitrators should have such powers.
All right.
But then if I have a weaker case, I would probably want I would want it to be dragged on as much as possible. So we are our clients' advocates after all. So, but yeah, I think neutrally speaking, I would prefer arbitrators have and exercise such powers.
All right. So just a last comment on you, Dr. Gültekin. So concerning the Libya case, I understand that if we were to be a state counsel or attorney, we should always refrain from just having the word enforceable in any arbitration agreement or maybe in the treaty, maybe in the treaty. So we should be, I think, cautious of that.
Indeed, yeah. I mean, that's what the decisions suggest, and I think it's a correct decision. So yes, if you're acting for the state, try and take any words which suggest, that the award may be enforced or enforceable, etc. At least in England, that would be deemed a submission. Sorry, a waiver of the
Immunity.
immunity from execution. Yes, and if you're on the other side, if you're on the investor's side, make sure you put in as much wording as possible that suggests that the award or decision will be enforceable, wholly enforceable to be precise.
So thank you very much. So next questions for Ms. Kaleloğlu. So actually one of the questions is already answered regarding the monist and dualist nature. You explained the ratio legis, so you answered that. So moving to my second question. So it's quite a novelty to having not any formal requirement for the arbitration agreement, and you addressed that under the New York Convention. It doesn't really end up, but what do you think are the risks, or are there any opportunities because of this novelty?
Yeah, I mean, look, I think it is great to be liberal. I think we can. I think you can try to have an arbitration clause that is not in writing, but in practice, like it is very, very difficult to prove that. And I think France is not the only place. Germany has been trying to do that. But in reality, it really doesn't move the needle in my view. And you will have like this is an international arbitration where the company or the state will have assets all around the world. So when it comes to awards, your job is not done. Your job is done when your client has been paid. And so you have to have an enforceable award. It is great for a state not to accept, be liberal in that context, but you will be in trouble enforcing that in various states, like I don't know, like Vietnam or something. So I think it's great on paper, but in reality, it's really doesn't move the needle.
All right, thanks. So, and also I realize that the definition of award, we don't see that in many jurisdictions. I really welcome that as someone who has worked on the definition and notion of award. So, what is actually, maybe you have a guess, what is the notion? I mean, does France try to prevent, for instance, the enforcement of provisional measures through the New York Convention, maybe? Is this maybe a reason for that?
Yeah, so. I mean, I've had a lot of cases just arguing out what is exactly final awards. Um, I think provisional measures. Um, I think they're quite clear that you cannot really enforce them. In some jurisdictions, again, I think you can try, but generally speaking, they're very difficult. But I feel like what they're coming at is this distinction between jurisdiction, decision on jurisdiction, and the awards. That difference, because some of the issues that tribunals decide, they actually finally they basically finally deciding on the issue. One of them is decision on jurisdiction. If the tribunal says we don't have jurisdiction, that is actually a final decision. It's not framed as an award. It's not framed as a final award. But if you look at what exactly it is a final award. And so I think that is what they are trying to explain, that, if the tribunal decides something finally, that should be considered as a final award within the terms of law so that they can be enforced.
Oh, thank you very much. And a couple of questions, just as you wish. Any one of you can answer. Maybe have a small debate. Like we've seen that there are many reforms both in France and UK. So, are Paris and London converging toward common international standards, or like deepening a competitive differentiation? What do you think?
Don, do you want to go first?
Just
Let me.
the mic, Dr. Wittstein.
It
Oh,
always happens, right?
ah,
It was my turn.
ah.
Thanks, Jim. I think on one level there is some convergence, and the reversal of ENCA, for instance, aligning London with Paris and other key jurisdictions on the law applicable to the arbitration agreement, and then of course most courts following the French court's example in the separability of arbitration agreements. I think in the arbitration world, and this applies to the arbitration decisions of the courts, there is some level of convergence where the principles are overlapping. But does that mean convergence of legal culture? I think not. These legal jurisdictions still have their own difference in approach and opinion. For instance, French courts are known to respecting and enforcing awards, even if it's been set aside at its seat, whereas other courts take a less liberal approach. So I think with the 2025 Act, there has been both jurisdictions have moved towards convergence, but there are still some differences. So I wouldn't say that they've totally converged. And that's a good thing, because then it gives the users of the arbitration community and its users a choice. Because if we were all black, then the importance of white would not be so visible. So I think there is some convergence, but also some differences.
All right. So, anything to add, or should I move on?
I don't think so. I totally agree. I think UK is trying to come to the same page with France. I mean, that's the truth with the 2025 reform, and what France is trying to do is like, how can I be better so that I can attract more seats. Again, I think London is a great seat and UK is a great jurisdiction to arbitrate, and so France unfortunately needs to do a bit more, sort of tell the world that I'm here, I'm still here. So that's exactly what they're trying to do. So I totally agree with Don.
Okay, so then you already answered my final question, which was which seat you would prefer with just.
I didn't. It's fine.
So, and you, Dr. Gültetan?
I would prefer Istanbul. I like coming to Istanbul.
That's a great answer.
But if it has to be a choice between London and Paris, I mean, I think London, because that's the one that I know. That said, I mean, I have done arbitrations, seats in Paris, Geneva, etc. During the arbitration, it doesn't really matter that much, I think. But in terms of the proactiveness and the level of kind of engagement you get from the English judiciary and the analysis, I think I quite like the London as a seat because of the judiciary. But otherwise, I think they're not really that too dissimilar. That said, in London, you have the right to appeal, which I understand you do not under model law jurisdictions such as Paris. So if you disagree with the tribunal on a point of law, London is again a better option, I think, as a seat.
Great. So I think we have spent a lot of time with answering also questions. I see we have already actually exceeded our plan. So then I'll leave the final words for Professor Yeşilırmak.
Thank you very much for lively discussions. Thank you, Dr. Doğan Gültutan. Thank you, Cem Kalelioğlu, and thank you, Dr. Ömer Faruk Kafalı. We are also thankful to Yağız Sankol for his great assistance. This webinar is brought to you by Dispute Resolution Center of the İbn Haldun University. Thank you very much. See you next time, hopefully.
Thanks a lot.